We have no control over how our private data, such as location and search history, is collected, stored, and distributed. When people lack control over when and how details of their private life become public, it is a problem for individual rights. Numerous kinds of data points are digitally collected, stored, and distributed. In the digital world, these data points relate to human behavior on a broad range of habits. Anything is recorded, from the amount of time you spend on a website to your search history and physical location. The socially destabilizing effects of this reality are bad enough, but when law enforcement works closely with corporate entities to easily obtain your digital information, which would otherwise remain private, that is more than just a social relations concern. The use of reverse warrants is increasing. What are reverse warrants? They are requests made by law enforcement to a company when they want to access data that is relevant to a criminal investigation. Ironically, the breadth of these search warrants, combined with the lack of any particular suspect, makes them functionally indistinguishable from the general warrants that the Fourth Amendment was designed to prevent. John Ellis, a forensic discovery expert, provides insight into the process law enforcement uses when working to obtain data from companies like Google. The three-step process begins with law enforcement obtaining private data that is anonymous, i.e., it does not show the identity of the users. Law enforcement officers often point this out, saying that they protect privacy by ensuring personal information is not initially revealed. However, under this scheme, privacy rights are illusory, because the purpose of attaining anonymous data is to eventually unmask one or more individual users. This is particularly troubling when combined with other significant facts. First, we have zero control over whether companies can collect our location. The process of preventing Google from tracking location is so complicated that it baffles its own employees. Many wireless companies hold on to consumer data, such as location, for months or even years. This leads to a porous relationship between private companies and government agencies. Simply put, it is not difficult for the government to obtain location data from tech or communications companies. The massive troves of data held by private companies are often relevant to law enforcement investigations. Because of existing legal structures, it is easy for agents to obtain a court order requiring companies to produce caches of data before a suspect is even identified. The logic of geofence warrants can be applied to other types of information. For instance, the first legal challenge to a reverse warrant seeking search engine history has already been initiated. Given the amount of information available on the internet, it is not hard to imagine these warrants being used to obtain data far beyond location and search history. Solving this privacy conundrum won't be easy. But one thing is clear: the judiciary is not prepared to act swiftly in protecting our privacy. Although the Supreme Court's ruling in Carpenter versus the United States recognized an individual privacy interest in cell site location data, the extent to which digital information is protected remains unclear. While court battles are fought, our privacy protections are far from guaranteed. Generally speaking, right now, Americans simply don't know how or when data about their identity is collected, stored, or distributed. In the digital era, our individual privacy rights are teetering on the edge of extinction. To uphold the constitutional purpose of preserving the blessings of liberty to ourselves and our posterity, we need significant legal and cultural changes. Without these changes, the conditions that allow for individual privacy rights to exist may disappear, spelling the death of freedom as we know it. To protect privacy, we need to start asking fundamental questions before adopting new technologies. We should expect companies to be able to answer, in plain English, how they manage consumer data. Companies that rely on collecting and storing significant amounts of individual data points tied to human behavior present more future risk. We need to engage with these companies cautiously. Lastly, legislative bodies should codify strong warrant requirements that undercut the porous relationship between corporations and state actors. Currently, it is far too easy for companies and law enforcement to collaborate closely, allowing government agents to easily access large consumer databases.